In sobering news on February 4th, the president announced that today our nation marks another tragic milestone. 900,000 American lives have been lost to COVID-19, adding that they were beloved mothers and fathers, grandparents, children, brothers and sisters, neighbors and friends. Each soul is irreplaceable. And marking the first anniversary of the declaration of a pandemic by the World Health Organization on March 11, 2021, the president addressed the American people to announce the American Rescue Plan to place the nation on a war footing when the total deaths in America totaled 527,726. That's more deaths than in World War I, World War II, the Vietnam War, and 9/11 combined. And about a little shy of a half of that current fatality count that we have today. Stating again in sober terms, they were husbands, wives, sons, and daughters, grandparents, friends, neighbors, young and old. They leave behind loved ones unable to truly grieve or to heal, even have a funeral. But I'm also thinking about everyone else who lost this past year to natural causes by cruel fate of accident or other disease. They too died alone. They too leave behind loved ones who are hurting badly. And last year was the deadliest year in American history. This year, according to the Wall Street Journal, is the sickest year in American history due to infections arising from the Omicron variant. Reassuring the nation, however, the president had said, "We know what we need to do to beat this virus. Tell the truth. Follow the scientists, the science, work together, put trust and faith in our government to fulfill its most important function, which is protecting the American people. No function more important. We need to remember the government isn't some foreign force in a distant capital. No, it's us, all of us, we the people," he said. And months ahead of schedule, earlier than expected, the president pledged to the American people a bold initiative with a goal of beating our current pace of 2 million shots a day, outpacing the rest of the world, as well as making every adult eligible for a free vaccine, although not yet FDA approved and still under a restricted emergency use authorization, by May, when he pledged to launch with our partners new tools to make it easier for you to find the vaccine and where to get the shot, including a new website that will help you first find the place to get vaccinated and the one nearest you. No more searching day and night for an appointment for you and your loved ones, the president promised. The president had a plan to vaccinate teachers and school staff, including bus drivers, stating that we can accelerate massive nationwide effort to reopen our schools safely and meet my goal that I stated at the same time of about 100 million shots of opening the majority of K-8 schools in my first 100 days in office, which would become the number one priority of my new Secretary of Education, Miguel Cardona. And a promise was made that if we do all of this, if we do our part, we do this together, by July the 4th, there's a good chance you, your families and friends will be able to get together in your backyard or in your neighborhood and have a cookout and a barbecue and celebrate Independence Day, which clearly did not occur. And on February 4th, the president in sobering tones announced, "Today our nation marks another tragic milestone. 900,000 American lives have been lost to COVID-19. Well, that was the speech that all Americans were delivered. But as stated by the Supreme Court in DHS v. Board of Regents for the University of California, often referred to as the DACA case that was decided in the summer of 2020, judicial review of agency action, to include the president, is limited to the grounds that the agency invoked when it took the action, classified at the time. And it is a fact that on December 6, 2020, just a week before the first COVID-19 countermeasures from Pfizer became available in the Commonwealth of Virginia, which were first not administered to the elderly in nursing homes, a known risk from the very beginning of the current public health crisis, but rather administered to public health professionals at the Centera Hospital in Norfolk. Nosocomial settings, which, quite distinct from the rest of the world, were not places associated with infection in the United States, except for in veterans care facilities where the doors were closed to visitors on March 10, 2020, and for which we have asked inspections by Senator Cory Booker and also Eleanor Holmes Norton, where in the facilities in their districts, over 1,000 veterans have died despite a lockdown policy at those facilities that began on March 10, 2020. But on that day, December 6th, the CDC admitted that for 6% of the deaths, COVID-19 was the only mentioned cause of death, and that 94% of the deaths mentioned more than one condition. And as reported by UPI on December 4th, 2020, a day upon which the nation had set a record for both coronavirus cases and deaths on the same day, where according to data from Johns Hopkins University, there were about 217,600 new cases and 2,900 deaths nationwide. There had been 14.15 million coronavirus cases and 276,400 deaths in the United States, according to Johns Hopkins, about 1/3 of the total fatality count today. But of that number, 6% would represent only 16,584 deaths attributed exclusively to COVID-19, just as 6% of the current total amounts to only 54,000 attributed exclusively to COVID-19. Beloved mothers and fathers, grandparents, children, brothers and sisters, neighbors and friends, each soul, as the president said, is irreplaceable, but still only 54,000, not 900,000, exclusively attributed to COVID-19, for which persons are being mandated to be vaccinated. Reviewing the data compiled as of December 5th, 2020, the CDC noted that the rates for Hispanic or Latino persons, non-Hispanic American, Indian, or Alaska Native persons, and non-Hispanic Black persons were approximately 3.8, 3.7, and 3.3 times the rate among non-Hispanic white persons, respectively. So it can be said, indeed, that for all deaths attributed to COVID-19 exclusively and with other causes combined, this disease has most adversely affected persons of color. And based upon early reports that had been received from China in a joint study conducted with the WHO, where a total of 1,800 teams of at least 5 epidemiologists, a robust study, had examined 55,924 laboratory-confirmed cases and properly their tracer contacts that had been identified by February 20th, 2020, which was just 1 month before the Virginia lockdown. The adverse impact upon persons of color perhaps could not have been anticipated based upon that available data. However, what was known at that time was that most people infected with COVID-19 virus have mild disease and recover. Most people infected with COVID-19 virus have mild disease and recover. What was known at the time was that approximately 80% of laboratory-confirmed patients have had mild to moderate disease, which includes non-pneumonia and pneumonia cases. And under the DACA case, judicial review of agency action is limited to the grounds that the agency invoked when it took the action classified at the time. What was known at the time was that individuals at high risk for severe disease and death include people aged over 60 years and those with underlying conditions such as hypertension, diabetes, cardiovascular disease, chronic respiratory disease, and cancer. And CDC Director Rochelle Walensky has recently reiterated that almost 3/4 of the fatalities to a novel coronavirus have had at least 4 comorbidities. And on December 13th, when the total death toll had surpassed 800,000, up 100,000 from the month before, the New York Times reported they are among the most vaccinated groups, but people 65 and older make up about 3/4 of the nation's coronavirus death toll. That report stated 75% of people who have died of the virus in the United States, or about 600,000 of the nearly 800,000 who have perished so far, have been 65 or older. 1 in 100 older adults has died from the virus. For people younger than 65, the ratio is closer to 1 in 1,400. A very, very contrary view to what has been portrayed in the press. So if you are not over the age of 65 and you do not have comorbidity factors, the general case fatality rate for COVID-19 or infection fatality rate is only 1.18%, compared with a 1.3% chance of becoming a fatality if involved in an automobile accident. But nobody has stopped driving to prevent dying in an automobile. And if you have been placed in reasonable apprehension of death or grave bodily harm from a novel coronavirus under the belief that your risks of fatality are any more than that, by definition under law, the Hobbs Act specifically, that is defined as extortion. And it is significant as both Pfizer and Moderna have begun to seek approval for vaccines for children under the age of 5. What was known by the WHO, based upon the largest sample size tracer contact study that had been conducted before the lockdowns in the Commonwealth of Virginia, was that disease in children appears to be relatively rare and mild, with approximately 2.4% of the total reported cases among individuals aged under 19 years. And according to UNICEF, as of January, only a little over 12,300 deaths have been among children under the age of 20 worldwide, with 58% occurring among adolescents ages 10 to 19 and 42% among children ages 0 to 9. And according to the CDC, as of February 2nd, a total of 910 children 18 and below have had deaths attributed to COVID-19, with 287 age 4 and below and 623 between the ages of 5 and 18. In the Commonwealth of Virginia, since the beginning of the health crisis, as of February 4th, only 13 children aged 17 and below have died from COVID-19. And again, if you have been placed in a reasonable apprehension of death or grave bodily harm for your child from a novel coronavirus under a belief that their risks of fatality are any more than that, by definition, under the Hobbs Act, that is defined as extortion. That is the law. Further, under the laws of the Commonwealth of Virginia, a party alleging fraud must prove by clear and convincing evidence, 1, a false representation, 2, of a material fact, 3, made intentionally and knowingly, 4, with intent to mislead, 5, reliance by the party misled, and 6, resulting damage to him. Under the precedent stated in 1984 by the state Supreme Court in Wynn v. Aleda Construction Company, clear and convincing evidence is such proof as will establish in the trier of fact a firm belief or conviction concerning the allegations that must be established, as stated by the Virginia State Supreme Court in the 1993 case of Thompson v. Bacon, quoting Walker Agency Incorporated v. Lucas, which was decided by that court in 1975. As noted in a recent opinion editorial by James Freeman in the Wall Street Journal, a recent study completed in Denmark and Sweden has concluded that lockdowns in Europe and the United States only reduced COVID-19 mortality by 0.2% on average, that sheltering in place orders were also ineffective, and that specific case studies had found no broad-based evidence of noticeable effects on COVID-19 mortality. And on April 2nd, 2020, we commenced the first and longest surviving challenge against the lockdown mandates because the ineffectiveness of cordon sanitaire policies, which is what they call, such as lockdowns and stay-at-home orders, were not only known before the lockdowns, but also specifically advised against by the WHO in their February 2020 report, causing the author of that study to remark to Julia Bellus in his interview with Vox Media that was published on March 2nd, 2020, that he was not certain that anyone had paid any attention at all to his report. 40 pages. Our lockdown challenge in the courts had a motion for temporary restraining order dismissed in Alexandria on April 15, 2020. Had the action against the city of Alexandria dismissed on June 24, 2020, and had the action against the governor dismissed in the Circuit Court of Alexandria on April 28, 2021. And after a dismissal in the state Supreme Court, that matter is now on petition for certiorari before the United States Supreme Court. We brought the first filed and longest surviving challenge against the non-medical grade facial covering mandates, commenced on June 2nd, 2020, based upon the fact that in March 2010, over a decade ago, the NIOSH had definitively determined that non-medical grade substitutes would be wholly ineffective in a respiratory tract infection pandemic. No study has overruled that study. And if that study had stated otherwise, there would have been no need for evolving science, which in fact contravenes the rule from the Supreme Court in the DACA case that judicial review of agency action is limited to the grounds that the agency invoked when it took the action, classified at the time. And after the celebration of the July 4th weekend, when the president's promise for a good chance for you, your families and friends to be able to get together in your backyard or in your neighborhood and have a cookout and barbecue and celebrate Independence Day, we filed in the federal court in Richmond a suit against the vaccines mandates, but raising a very specific allegation under the Freedom of Information Act. After the White House had failed to reply to a request for information it had acknowledged to have received on March 23rd, just a little over a week after the announcement regarding the American Rescue Plan. In its study completed in February 2020, the WHO had only found a secondary attack rate of less than 5% for COVID-19, which an epidemiologist knows is 4 times too low to validate the presence of a disease being transmitted from person to person and can only be deployed. not transmitted. And it is 12 times too low to set off a super spreader event. And the WHO specifically stated that it is not clear whether this correlates with the presence of an infectious virus. A pretty clear statement of medical, clinical fact, but the CDC has never stated a secondary attack rate for COVID-19 as it has for measles, smallpox, chickenpox, which raised a reasonable inference that that standard metric might be classified information, which it could not be unless the government owned the biological causative agent for COVID-19, and which would necessarily mean that it had to have been cultivated in a laboratory and not zoonotically evolved, as has been claimed even by the president's top medical advisor, Dr. Anthony Fauci. On May 7, 2021, the CDC had conceded that the infectious dose of SARS-CoV-2 needed to transmit infection has not been established. An admission stated after our FOIA request to the White House that had asked if that metric too was classified information, which it could not be unless the government owned it and would of necessity mean that it had been cultivated in a laboratory. Since 1870, when Robert Koch had examined anthrax and had developed what are called Koch's postulates, the scientific community has known how very readily to determine an infectious dose for any biological agent, and knowledge of the infectious dose is required to determine the proper correlates of protection measured in serological titers to enable pharmaceutical companies to develop an effective and not just efficacious vaccine without resorting to very large stage 3 clinical trials. But since March 23rd, the White House had elected a dubious right to remain silent regarding whether the infectious dose and or secondary attack rate were classified information, and the matter in the federal district court was dismissed on October 29th without that court compelling the White House to disclose the information. That action was brought up on appeal to the Fourth Circuit in December, where we were granted an opportunity, like was provided to the Brooklyn Diocese in November 2020, to present an application for pre-judgment injunctive relief to the justice assigned to the Fourth Circuit, Chief Justice John Roberts. And on February 14th, a response to the Chief Justice is due from the White House to explain their delay to the Supreme Court in providing a response to our FOIA request. Under USC 2332 Bravo A1A, whoever involving conduct transcending national boundaries and in a circumstance described in subsection B, kills, kidnaps, maims, commits an assault resulting in serious bodily injury, or assaults with a dangerous weapon any person within the United States in violation of the laws of any state or the United States shall be punished as prescribed in subsection C, which provides in relevant part that whoever violates this section shall be punished for a killing or if death results to any person from any other conduct prohibited by this section by death or by imprisonment for any term of years or for life. However, under 18 U.S.C. Section 2332 Bravo B1C, for jurisdictional purposes, the victim or intended victim is the United States government, a member of the uniformed services, or any official, officer, employee, or agent of the legislative, executive, or judicial branches, or of any department or agency of the United States. And to date, a total of 92 uniformed service members have been fatalities to COVID-19. Under 18 U.S.C. 2332 Bravo D1, the prosecution is not required to prove knowledge by any defendant of a jurisdictional base alleged in the indictment, which means that you don't have to know that you were trying to kill soldiers. And in electing a right to remain silent, at least with regards to criminal conduct involving terrorism, a person acts with requisite knowledge if he is aware of or willfully blinds himself to a significant likelihood that his or her conduct will materially support the organization's terrorist ends. That was stated in Holder v. Humanitarian Law Project, decided by the Supreme Court in 2010. And under Federal Rule of Criminal Procedure 6A, when the public interest so requires, the court must order that one or more grand juries be summoned. At least in the Sixth Circuit, where it was found that where the object crimes alleged were part of a broader conspiracy intended to promote enumerated crimes of terrorism, it has been held that the terrorism enhancement applies no matter which object crimes were assumed in the guilty verdict. So there is no need to determine beyond a reasonable doubt that a defendant or defendants conspired to commit any one of the named objects in particular. That was stated in U.S. v. Graham, decided by the Sixth Circuit in 2001. Similarly, the Seventh Circuit has held that if the act is among the litany of crimes listed in Section 2332 Bravo G5B, which include a bevy of the most harmful and odious acts in the criminal code, including everything from murder and torture to the destruction of government property, and it was calculated to influence or affect the conduct of government by intimidation or coercion, to include elections, or to retaliate against government conduct, then it is a federal crime of terrorism under U.S. v. Christensen, decided by the Seventh Circuit in 2009. And for all intents and purposes at sentencing, that person is, by definition, a terrorist. Since the White House has elected a dubious right to remain silent on all evidence, it appears that the novel coronavirus that was used as a justification for the lockdowns, as a justification for the non-medical grade facial coverings, and for the vaccines is the property of the government. And the government cannot create a reason to violate your constitutionally guaranteed rights or to manipulate your vote. And unless you can find some rational reason to determine otherwise, that is simply the way that it stands. This briefing is unclassified. Until next time, you have the right to remain silent, as you were. My name is Major Mike Webb, and by God, I am running for U.S. Congress. Next year, make the right choice, and we shall make America great again. Honest. And y'all come back now. Yeah. Carry on.
Sinner, do you love your Jesus? Sinner, do you love your Jesus? Sinner.
This advertisement was authorized by Mike Webb.
Jesus, soldiers of the cross. Sinner, do you love your Jesus? Sinner, do you love your Jesus? Sinner, do you love your Jesus? Soldiers of the cross.
Thunk, I could have had a vaccine.